for this year actually pertains to the payment, among others, of the construction of our new SC complex in BGC, Your Honor. And there is already progress insofar as this matter is concerned, because we just completed the international design competition. Thereafter, we will already be engaging the services of a consultant for purposes of
I just want to clarify, since the judiciary, since your fiscal autonomy, the 17.6 billion, if not totally spent by December, will all of this revert, or only the PS stays with the Supreme Court? Can I be clarified with that? Or everything will revert to them?
Because of the fiscal autonomy, Your Honor, may I, if I may be allowed, Your Honor.
Everything will stay with you?
Yes, Your Honor, because...
So, okay.
Because
so
of,
in your case, right, nothing, so it's not a 12-month period insofar as a judiciary is concerned?
Because of our fiscal autonomy, Your Honor, as provided in the Constitution, Your Honor.
Teka. Madam Chair, I assume you can realign.
Yes, Your Honor.
So that's what you will do?
Yes, Your Honor, as what we have done in previous years, Your Honor.
Right.
Yes, Your Honor.
Because of your fiscal autonomy,
yes, Your Honor,
you can realign. But by the rule of the Supreme Court, the realignment can only take place in December when the savings is determined.
Yes, Your Honor.
Baka naman exempted ang Supreme Court sa rule ng Supreme Court? Hindi naman.
Hindi naman po, Your Honor. Hindi naman po.
Baka naman ngayon pa lang magpa...
Yes, Your Honor.
I just want to be clarified. I ask this every year, but it's never clear.
Yes,
because Congress has fiscal autonomy, but we revert funds to Treasury. The judiciary has fiscal autonomy, but does not revert funds to Treasury. So, may I be educated on the difference between other institutions which have fiscal autonomy, but revert funds to Treasury, and the judiciary?
Yes, Your Honor. I think as provided in the Constitution.
I attempt to answer that.
Yes, Your Honor. Thank you, Your Honor.
In the presence of Justice Peralta.
Your classmate. I remember every year you joke it.
My classmate already retired.
Justice Perez.
Justice Perez. My roommate already retired.
Your roommate. No, Justice Peralta is younger than you.
Yes. He was... first, we enjoy fiscal autonomy. As interpreted by the Supreme Court, all constitutional bodies, so the Congress, COMELEC, COA, Supreme Court, etc., the heads of these institutions can realign savings. That's the basic rule. So everybody can realign savings, including the Senate President, including the Speaker of the House, including the Chief Justice. But by the ruling of the Supreme Court, we cannot realign until there is a determination that there is savings. The situation, of course, is that the savings can only be realized in December. So you are confronted with the situation, Madam Chair, where because the appropriation is only good for 1 year, it will expire at the end of the year. So I assume that by December, all the heads of these constitutional bodies will now declare savings on those items which are not spent. Now, I cannot answer you what will happen if the savings, if the realigned savings continue to be unobligated as of the end of the year. I have no answer to that.
I am confused.
Now, yes. That is, but the Budget Secretary has included, I think, a special provision, or took the position that they would want a stamp of approval from Congress, and instead of simply exercising their power to realign, they would want supplemental budget drawn from the unobligated funds. That's how I understand I may be wrong on that, but
so the 600 million that the judiciary is asking can actually come by December if the 17 billion will not be spent, or part of it.
Yes, but
Correct?
may I just
Kaya
perhaps...
kalahating taon. By
Yes,
now, I'm sure you've spent much of it
Yes,
already.
yes po, Your Honor.
Because let me also relate to you, Madam Chair, a discussion last night in the Ladakh. The President wants more funds for the armed forces because of this conflict in Marawi, for whatever reason, arms, etc. And he said, I will move to the armed forces my intelligence funds from the office of the President. I said, you know, you may not, if you not need that today, you may not be able to do it because under the ruling of the Supreme Court, it has to be declared as a savings, and you can only declare it as a savings in December. And so what is the remedy? I suggested during the meeting that the remedy should be, they should think of filing a bill in Congress amending the General Appropriations Act so that you realign now the, say, for example, the intelligence funds from the President to the armed forces. Then there is no occasion to dispute that this is not savings. You don't have to wait for December, but you need congressional approval. Papasa sa Supreme Court yun, I'm sure. No comment. No, because
Perhaps the President may not realize that there are CONFI and Intel funds lodged in the armed forces in every major service of the three. There is also in ISAP, there is in GHQ, and he has in his office.
Yes.
So
he's talking about the funds in his
sila sa
office.
kanya, and madami naman na nilagay na sa mga
kung
major
doon lang sa, kung let's say, the intelligence funds of the Army, they want to use it for, I don't know what the rule will be, if they want to use it for, say, purchase of guns. I would not know if they can realign from intelligence funds to purchase of guns before December. I do not know. I have no answer. They cannot under the rule of the Supreme Court. So they might as well, I think the only remedy is to file a bill which in effect will amend the General Appropriations Act and reallocate the funds already in the GAA so that you will not need a National Treasurer certification as to the availability of these funds, and you are not actually increasing the national budget. You are just realigning from within the budget allocations. But since you cannot do it until December and you need the funds now, you have to go to Congress.
Well, thank you for that, Senator Drilon. I'm glad you mentioned, because after this, I'm putting together all the intelligence and confidential funds that I put in the 2017 GAA, and there is a lot under the AFP, under the DND, which the President may not know, so they keep on asking from his 2.5 billion OP Intel Fund when they have not even used
You are not
theirs.
supposed to know how the Intel funds are used.
I want to know, because that's COA-able. No, the Intel funds are also
Yes.
subjected to COA.
No, they
No,
are subjected to a closed envelope accounting.
By certification.
They say, I paid Senator Dillon 1 million pesos for intelligence. They place it in an envelope, seal it, and that they accounted for 1 million.
Yes.
So-
Okay, anyway, we recognize the Court of Tax Appeals Presiding Justice Romante Rosario. Yeah, in case your staff texted you that you have no budget, no, we were just joking. Yes,
I have a question
Sir.
in relation to the budget.
yes.
I was looking at this number of field positions. Correct me if this data is wrong. According to the data that was given to me, the number of field positions have remained almost constant, and so has the number of authorized positions. They have remained constant, which only means that there are no additional hiring of any significant number. Specifically, let me put it on record. From 2016 to 2017, for example, the number of authorized positions in 2016 was 36,270. the number of filled positions is 25,160. In 2017, the number of authorized positions is 37,730. The number of filled positions is 25,154. In 2018, the number of authorized positions is expected to be at 37,230, and well, of course, the field position would be a speculation at this point. But just on 2016 and 2017, there appears to be no new hirings, and yet you have increased the number of authorized positions. Why so, Mr. Villanueva?
Yes, Your Honor.
First, are the figures accurate? More or less.
More or less, Your Honor, more or less.
More or less, oh.
Yes, Your Honor, but the increase, perhaps, Your Honor, is because of the creation of new positions for newly created courts, Your Honor. That's why there is an increase in the authorized positions, Your Honor.
Well, from 2016 to 2017, there is even, there is an increase.
Yes, Your Honor.
Less than 1,000 positions.
Yes, Your Honor.
So, yeah, but the number of field positions almost the same. In fact, it has gone down by six positions. Apparently, the retirees, the post vacated by retirees were filled up. But nevertheless, the question is, why is there so many unfilled positions?
Your Honor, may I just respectfully mention that, for one, because there are the increase is accounted for by the creation of new courts, Your Honor. So the filling of these vacancies will have to be done first through the JBC vetting the applicants for the judgeship positions before the filling of the personnel positions, Your Honor. Likewise, Your Honor, there are some positions that are mentioned there that may be considered as part of the unorganized and but with only NOSCA documents coming from the DBM, Your Honor. That's why it's sometimes included as well as part of our plantilla position.
Except that it has remained constant, no?
Yes, Your Honor.
In other words, pare-pareho ang unfilled position, meaning talagang hindi kayo nag-hire. So that's the question as a policy issue I'm raising.
Yes,
why are we not hiring more people when in fact we are authorized to do so under the General Appropriations Act?
May I just a disclosure, Honor, that the JBC for 2015, Your Honor, processed about 187 positions, Your Honors, and submitted the shortlist to the Office of the President. That's for 2016, and an additional 123 plus, Your Honor, vacancies for 2017. So that's the reason, Your Honor.
Yes, Justice Villanueva.
Yes, ma'am.
There are about 11,000 unfilled positions.
Yes, Your
so a few hundreds or 100 from the JBC's process will not explain sufficiently why there are so many vacant positions.
Yes, Your Honor.
You know, I can assure you, we will not remove this budget.
Thank
what
you.
I'm just saying is why we keep on. No, I hope you can listen to what I'm saying.
Yes.
Yeah, because there are, all I'm asking, Madam Chair, as I said, we are not going to reduce the budget, but I think we are entitled to an explanation.
Yes, Your Honor.
Why we have authorized 36,000 positions, 36,270 positions. Last year, only 25,160 were filled up, or something like 11,000 positions were not filled up,
yes,
authorized positions. So the fact that the JBC takes a little time cannot explain this disparity between the authorized positions and the filled positions.
Yes, yes, Your Honor. But Respectfully, as I was mentioning, Your Honor, some of the positions that are included in our personnel level, Your Honor, are unfunded but included already as part of our authorized because there was funding already, Your Honor, but we have yet to receive the NOSCA or the notice of organization, staffing, and compensation allotment, Your Honor. And then second, some of these positions are actually being processed already by the Selection and Promotion Board of the Office of the Court Administrator. And with respect to the new positions, Your Honors, actually, based on our records, about 3,848, Your Honors.
That is why was asking you whether or not this was more or less an accurate number.
Yes, Your Honor.
Because even in 2015, you had a number of filled positions per the report to me of 25,133.
Yes, Your Honor.
Out of authorized positions of 35,893, or about 10,000
Yes, Your Honor.
vacant posts. In 2016, it was about 11,000. In 2017, presently, it's about 12,000. Totoo ba ito?
More or less, the vacancy rate is actually around 25 to 30%, Your Honor, because that involves not only previous existing positions but also newly created positions, Your Honors. Because
would you have a ready record of what these unfilled positions are?
Yes, Your Honor. Based on what was provided us by our data reconciliation, Your Honor, yes, we have.
If you can submit, yes, if you can submit what, and so that, because there is also a possibility that you collapse this. I mean, I know if these are judges' positions, but obviously some of these positions are not attractive to the applicants. Baka yung salary grade is very low, you know.
Stenographers, we have problems on stenographers.
The stenographers, so many of them are stenographers' positions.
Yeah, some of the
or maybe items in Marawi City where no one wants to take.
And also the pay, especially the pay, they go to Congress. They go to Congress, to Senate, because they don't have work.
So maybe, Mr. Justice, if you can give us an accurate why there are so many vacancies in the judiciary. Be candid with us. Sasabihin mo, ang dami yung bonus sa Senado, kaya yung mga stenographers namin napupunta dyan. O mga ganon, ano?
We recognize Associate Justice Carl Miranda.
I'm sorry.
And Justice Roman was already recognized.
Mr. Carl Miranda, you look like the Sandigan Bayan fits your, you become handsomer since the last time I saw you in the mukha ng justice, ha? Talaga naman. Oh, yeah, but seriously speaking, maybe Justice Peralta, if you can give us your recommendations, how to solve this?
Probably to exempt us from the salary standardization law, Your Honor, because it's very hard to employ stenographers in the courts because they prefer to go to Congress, Senate, and Congress. Because the pay really is very low for stenographers, Your Honor. Mababa ang sweldo. If you have 100, how many courts do we have? RTC and ML?
Total of 2,300.
2,300 courts, and we have an average of 2 vacancies per court. So if you multiply 2,300 by 2 vacancies per court, that will be already a little more, more than 4,000, Your Honor.
It's a fact that the Congress and the Senate staff are paid well. Stenographers, for example, what's stopping the judiciary from paying your staff, your stenographers, similar to what we're paying them?
Because of the salary grade, Your Honor.
No, the same salary grade is applied.
Pareho
po.
And the work in the courtroom, Your Honor, is harder. Yeah. Because every day they have to attend trials. Alam naman nila eh. And they do not work on Fridays.
Napatanong ni Senator Drilon, bakit daw hindi nyo gamitin yung savings nyo para dagdagan sa bonus sa mga tao to make it more attractive? There's nothing wrong with asking
We are
for
trying
putting
to
it on record.
recruit contractual employees, Your Honor, to fill up the vacancies. We try to recruit contractual stenographers to fill up the vacancies, but only for a short period of time.
Would contracting out to a service company stenographic work be prohibited?
Individual contractor, Your Honor.
No. Service company.
Oh, that's dangerous, Your Honor.
Yeah, I know.
Because their work is highly confidential.
That's right.
Yeah,
Yes.
it's highly confidential. The other reason why they do not stay long is that, and they prefer Congress, they do not work, they work Monday to Fridays. Your stenographers here, they don't work on Fridays.
Yes, but we work for 10 hours a day.
Yeah, yes, Your Honor, but the stenographers, especially now that we are implementing the continuous trial by September 1, where trial will now be held morning and afternoon. You can just imagine with
No problems with exempting the judiciary from the salary standardization, but you have to get the concurrence of DBM, because DBM is the one who administers our salary structure.
somebody should sponsor that.
We're ready to
proposal.
sponsor that. But
The-
let me be very clear, Justice, that even if it passes both houses of Congress, meaning the removal of the judiciary from the salary standardization law, it can be done. But if the DBM will not agree, pagdating po sa Malacanang, ibibito po yan. That is why you have to have the concurrence of DBM on that. But that's basically what it is.
But again, you have the freedom, the liberty, you have the resources to give the monthly bonuses to make it more attractive for your stenographers, etc. You can do that.
Yes, Your Honor. But of course,
Copy the Senate model.
there is
Tell them how much they're earning and their allowance.
Ma'am, mabigat ang trabaho ng stenographer sa courtroom. Mabigat. They even go to private law firms. We cannot prevent them from transferring to the private law firms. They pay high, Your Honor. How much do they earn ba?
Yung sa private po, hindi ko na kayang ihambing. Pero ibig ko sabihin, yung mga Senate staff, you can actually see what the bonuses that they're receiving. No, it's good because the people here work very hard and they're very competent. So
Yeah.
you can actually, nothing would stop you from doing this similar bonuses so that to make it more attractive to people.
that matter of giving additional personal benefits, Your Honors, is
Justice,
before the Supreme
yeah.
Court. It's up to them to decide on it, Your Honor.
May I suggest, this
Yes,
is
Your Honor.
because, looking at this kind of data will be forever there. 10,000 vacancies, 12,000 vacancies, taon-taon, kahit 5 taon mo titingnan, ganun pa rin yan. Why don't you present this problem to the DBM and say, how can you help us? We want to hire more stenographers, for example. How can you help us here? Otherwise, the Congress, every budget cycle will ask us, why are we not hiring? Maybe you can collapse some positions, I don't know. But you have to have the assistance of the Department of Budget, and whatever, on our part, whatever is needed to legislate, we will obviously cooperate.
Your Honors.
Well, no, we will help, obviously, but it has to, but you have to get the cooperation from the budget. That's the reality of our life.
But the 10,000 which are not filled,
They're
there
being
is an
transferred.
allowed appropriation, but the cash is not downloaded to you.
Your
Only
Honor,
when you fill it.
there is an automatic
It is-
release,
it's
Your
a-
Honor, on a quarterly basis, Your
Oh,
Honor, of the budget
Okay.
of the judiciary.
So whether filled or not, it's with you.
Yes.
It's the appropriation or the allotment is accompanied by the cash.
Yes, Your
Correct?
Honor. That's why we continue to process all of these vacancies,
Okay.
Your Honors.
So the cash allotment, the allotment plus the cash is automatically given whether or not you fill it.
Yes, Your Honor,
And it
because
does not revert annually because your fiscal autonomy and you, because you
yes, that's a feature of the fiscal autonomy
correct. You
privilege.
actually have your, since the GAA of 2006, 2006. They still have it. From 2006.
That's 10 years ago, at least.
Yes, you still have it, right?
Yes, Your Honor. Yes, Your Honor.
So it reverts back.
Ay.
Nothing is returned. Unlike
but they are,
COMELEC.
but these have been
COA.
obligated already, Your Honor. Every year, when there are savings, Your Honors, these are being obligated already by the Supreme Court through a Supreme Court resolution, Your Honor. So, in effect, all the budget are actually accounted for, Your Honor. And there is appropriation or allocation. Yes, po. That's why there is nothing that
So
is
the
being reverted back.
unreturned already allotted with cash annually, since time immemorial, all of those listed here
Yes, Your Honor.
are being spent.
Yes, Your Honor, because once as mentioned already by Your Honor, once there is savings determined by the end of the year, then there is an obligation, no, being done for and programs are being identified to allocate these savings, Your Honors.
You may have, we may have discovered a gold mine here because TBM gave us this after. This is actually in the NEP. Please give the Judiciary Finance head
Yes, Your Honor.
the list of this. It's in your NEP.
Yes,
you
po,
have
Your Honor.
so much unobligated from 2006. Please spend it. Ang dami niyo
Yes, Your
pa.
Honor.
You know.
We're ready to submit, Your Honor, where these amounts, the amount of savings were earmarked for, Your Honor. We'd gladly
Yes.
submit the data regarding
I'm
it, Your
just
Honor.
putting this on record so that you know your resources.
Yes, Your Honor.
So
Yes,
that
Your Honor.
please spend it. You have 3.7 billion continuing appropriations for the past 11 years.
Yes, Your Honor.
Do you know this?
Yes, Your
So
Honor.
gamitin nyo, sayang.
Yes, Your Honor.
Because you're asking Congress for additional 570 million. You may not realize it. You have 3.7 billion continuing appropriations.
May I just point out, Your Honor, that with respect to the items that we're asking, Your Honor, for the 2018 budget, there are no line items, no, for some of these amounts that we're asking for. That's the reason why we need the items, Your Honors. Otherwise, we are
Ganito.
limited, Your Honors,
Okay.
with how we would be able to obligate our savings if there are any, Your Honor.
Okay. Let me correct myself. The 3.7 continuing appropriation was 2016. 2017, it's 1.2 billion. So, yes, you're correct. It shows that you spend it.
Yes, Your Honor. We
Please-
obligated those amounts already, Your Honor.
Sure. Please give me a breakdown of how you will spend the 1.2 billion continuing appropriations as of this year, so that then the breakdown which you showed earlier in the slide of your additional appropriation of 570, so that I can justify it if and when. No promises, nakangiti ka na, hindi pa kasuradong makahanap ko yung 500 million na yan. Just show me please the 1.2 billion breakdown. If you don't have it now, that's okay, please submit it.
Well-
And this is for the whole Judiciary or only Supreme Court? Supreme Court pa
Supreme
lang
Court
ito.
lang, only for the Supreme
Supreme Court and
Your
lower
Honor.
courts.
But the other courts can actually submit, Your Honor, although
Sure.
the level of savings is not as similar
It's
to
not,
that of the Supreme
Okay,
Court, Your
just to
Honor.
clarify,
Yes,
this
Your
is
Honor.
Supreme Court and lower courts. You have
Yes.
1.2 billion as of 2017 continuing
Honor.
appropriations. What is it earmarked for?
Yes,
And
Your
then
Honor.
this 570 is Supreme Court and lower courts also.
Yes, Your Honor.
Prioritize so that we will see what could be given.
Yes, Your Honor, we can provide the data, Your Honor, as requested, Your Honor, and we'd gladly give it to the committee, Your Honor.
But it's still, I still have not received an answer why the others with fiscal autonomy return their funds to the Treasury. It only the Supreme Court or the whole Judiciary
Ye-
reverts it to themselves.
Your Honor,
Because COA returns it to Treasury. Does it not?
Yeah.
COA and Ombudsman and COMELEC?
Your Honor,
I want to see the difference.
may I just state that as provided in Section 8 of the Constitution, Article 8, Your Honor, insofar as the amounts that are being appropriated to the judiciary is concerned, that cannot be reduced to amounts that were given, no, for previous years, Your Honor.
for capital
So if we
outlay.
turn it over, Your Honor, that might in a way be violative of that prescription of non-reduction of the budget. If we will turn over, Your Honor, the amounts, that's and Your Honor, I have to say that Judiciary, Your Honor. Actually, Your Honor, there is a CPAG resolution. Yes po, Your Honor.
So
On the
you're
record.
teaching now, okay, on the record now.
On the record, are you saying that if we do not return, I mean, you're talking about Congress, Senate, if we do not return what is in excess of whatever what we cannot obligate, etc., that will be sustained by the Supreme Court as consistent with our fiscal autonomy?
You're defending all institutions with fiscal
not only.
autonomy.
In other words, what is good for the goose is good for the gander. If it's the Supreme Court, if good for the Supreme Court, it should also be good for the Senate, and the Congress, and the Ombudsman, and the COA, etc., and the COMELEC.
Although, no comment,
Although if we just follow the Supreme Court decision, we will be safe. I mean, your precedent is a Supreme Court decision.
I want to be, your chair wants to be educated.
yes po. Your Honor,
Every year I ask that question and it is left hanging.
Yes po.
I want to understand, can you please submit to us a justification?
yes po.
I would just want to see the difference
Yes.
of various institutions with fiscal autonomy and the different treatment
Yes po.
in the budget, because I want consistency.
Yes po, Your Honor.
But don't worry, I will not compel you
Thank you
to
po.
return.
Yes po.
In fact, I'm showing you that you have funds.
Yes po.
And if the funds that are continuing, 1.2 billion, is still needs augmentation, of course, I'm always very supportive of the judiciary's budget. But I want to understand,
Yes, po.
and if you're saying there's a Supreme Court decision which justifies your reverting it to your savings and for realignment, then COMELEC, COA, Ombudsman, Congress, both houses can actually do that.
May I just put on record that
Yes.
when I was making a reply, Your Honor, I'm only speaking for the Supreme Court. I cannot speak for the other constitutional bodies, Your Honors. And I guess the decision of the Supreme Court in Benson versus Drilon also more or less clarifies the fiscal autonomy feature of the judiciary, wherein it enjoys automatic release. And
That's
at the
right.
same time, the budget cannot be reduced as compared to the
So my
previous.
question is, what is the difference of the fiscal autonomy feature of the judiciary and the fiscal autonomy of the other institutions in government?
My answer will only be based, Your Honor, on the constitutional provision regarding the non-reduction, Your Honor, of any budget.
And the constitutional provision on non-reduction does not only refer to the judiciary or just the judiciary?
As far as I can remember, Your Honor, it applies to the judiciary. I cannot speak for the
so
other
that is
agencies, Your
the
Honor.
unique feature of all, compared to those with fiscal autonomy, the non-reduction of the judiciary budget, while the others may have fiscal autonomy but return it to Treasury because there is no constitutional provision on non-reduction. Is
Based on the
that
decision as well
Madam
of in
Chair.
Benson
you
versus
agree,
Drilon.
Mr. Former Justice Secretary? We,
It is,
Before you-
what is prohibited,
may I please recognize Justice Amparo Kabutahitan? Yes, PJ.
Yeah.
Yes, okay, Senator
I
Drilon.
am looking at Justice Peralta. Yeah, no,
I
answer.
understand.
What is prohibited is a reduction of the appropriation. We cannot reduce the appropriation for the current year as compared to last year. But technically, it is not a violation of of reduction if we return what is unspent, because what is prohibited is reduction of appropriation. If it's already appropriated and you do not use it, the rule in the other agencies is you return. But the rule, the Supreme Court has interpreted it that they continue to hold on to it because it has been appropriated.
There is an obligation, yes, Your Honor.
And if you return what has been appropriated, then it reduces that year's appropriation or obligation.
Yes,
No,
Your
that's
Honor.
not. That's where I disagree. Because what is prohibited is the reduction of the appropriation in...
If you disagree, you're saying that they must return.
I'm not saying that they should return. I'm just saying that
You
if
disagree,
their interpretation is that they are not obligated to return as part of the fiscal autonomy. I concur in the result. Yun. Yeah.
I'll just receive that from you. I would be happy to receive that interpretation of the judiciary, but I want to be enlightened, hopefully in your answer to my question, to my query, which is every year,
Yes, po, Your Honor.
what makes the judiciary unique? What is that specific... Sige, hindi ka naniniwalang may sagot dyan. Sige.
Your Honor, please.
I want to understand, because the others can actually cite the judiciary and not return to Treasury. Now, Congress will have an idea
Don't
and say,
worry, Madam Chair, I will not ask that in plenary, so that you don't have to respond to it.
scared, tatanungin niya ako sa plenary.
No, hindi ako magtatanong.
Yeah. Section 3, judiciary shall enjoy fiscal autonomy. Appropriations may not be reduced by the legislature below the amount appropriated for the previous year and after approval. Appropriation. And what Attorney Villanueva is saying, when they return, it reduces the appropriation. Sinuli eh. Tama naman siya. Sinuli. Maybe the interpretation, your interpretation is different.
Anyway, sige.
But my question is not, regardless of the interpretation, is what sets the judiciary apart from the other institutions that have fiscal autonomy that the judiciary may retain and may not return while the others return?
Yes. And like I said, Your Honor...
I would be happy to be educated on that point.
Yes, Your Honor. Like I said, in the case of Benson versus Drilon, Your Honor, there was mention already on what fiscal autonomy means, Your Honors, and it also specifically mentioned about, of course, direct, immediate release, automatic release of the budget, and yes, Your Honor.
Which applies to all others with fiscal
Yes.
autonomy.
And
therefore, COA can say the same thing, and Ombudsman and Congress.
Yeah.
Correct.
Yes, Your Honor. And then, although the non-reduction is there also, Your Honor, but the Supreme Court, since this is an appropriation already on an annual basis that is being given, what it does is that it obligates any savings already, Your Honor. That's the reason why it is not returning, Your Honor, the amounts if there are
There
savings.
is no more savings.
In effect, there is no more savings
So
to
there is
return,
no
Your
more
Honor.
savings to realign.
Yes, Your
Because
Honor.
the savings have been obligated before December 31.
Yes, Your
So
Honor.
the question is academic.
To a certain extent,
Because there is
yes, Your-
no retention of money.
Yes, Your
It's
Honor.
all spent.
Because it's obligated already, Your Honor.
Oh, yeah, that's your answer. If you're asking plenary.
I'm sorry, I was
The,
I was reading by...
if you're asking plenary, the response is, that question is theoretical because in point of fact, there is no savings at the end of the year to return to the Treasury. There is no savings to return because it is already obligated and no longer savings. So there is no savings.
Correct.
There is no, since there is no savings, whether or not there is an obligation to return is immaterial.
We're talking of the 12-month cycle or even the previous 2-year cycle, regardless.
Lahat na yan, no? Lahat na yan.
Even with the 12.
Yeah. That's how to justify it in case you're asking plenary.
But the other institutions...
Tama ba yan, Justice Daddy?
The other institutions can use the same reason.
Yeah, the other institutions can do
The
the
other
same.
institutions can use the same reason. I failed to ask them why they return, why they don't follow the judiciary example. Justice Martirez.
I don't think the other institutions can use the Supreme Court experience, because if I remember right, the 2016 GA, there is a special provision number 10 under the Supreme Court that allows the Supreme Court not to return whatever savings it has, which was vetoed by President Aquino. This was the 2016 GA, and this is a special provision number 10, if I remember right.
If it was vetoed,
Then you cannot.
then theoretically you should return.
I remember right, in January of 2016.
So you are violating our 2016 GA, the Supreme Court.
I really don't know, because it
I
was
don't
vetoed.
think President Aquino
This-
would
the-
veto that provision.
He was
Let's
asking
see.
the Supreme Court to return, the judiciary to return unused funds. This is what I read in the papers, actually, particularly the Philippine Star in January of 2016.
There was nothing to return.
Yeah. But I think more or less, Your Honor, we have provided the reason why there is I mean the savings, if there are any, that they are being obligated, no, by the Supreme Court simply because they are needed, actually, Your Honor. And likewise, we wouldn't want to we would like to assure Congress that the budget that we're requesting are actually what are needed, no, by the judiciary.
That is clearly understood. We have full support of your budget. And in fact, all I'm saying is that the reasons you are giving for your fiscal autonomy and not returning it to Treasury can be used by the same institutions that have fiscal autonomy as well.
If I may, Your Honor, the same actually praise can be found for constitutional commissions and other constitutional bodies, at least for the three constitutional commissions, which includes the COA. They also enjoy fiscal autonomy, Your Honor. And with
And their funds.
of course, as the third branch of government, we have our own processes, Your Honors, and like I said, the budgets that we are always asking are the amounts that we really need for our operations, Your Honors. And we submit that there may be some unspent amounts at certain points, Your Honors, before the end of every fiscal year, but these are obligated, Your Honor, to answer the needs of the judiciary, Your Honor.
The others. Justice Tang, is there anything you'd like to add to the
First,
conversation?
can we, I'd like to ask questions on the Sandigan because we created last year, ba yun? 2 years ago, 2015, additional 2 divisions in the Sandigan. This has been fully organized.
Yes, Your Honor.
And all the way, 6 justices were appointed together with full personnel. The purpose of adding 2 divisions is the known fact that it takes time for the cases to be resolved. May we know, we do not expect it to be resolved on year 1, but may we know when we expect the length of time before the case is decided with the creation of the 2 new divisions, and given especially the fact that yesterday the President made a statement that ang tagal-tagal na ng kaso ng ibang senador, bakit hanggang ngayon hindi pa na-desidihan? Criticizing the Ombudsman, when in fact these cases are already with the courts, with the Sandigan. So that's why it gives, it emphasizes the need for us to take a look as to how the Sandigan Bayan is now reacting or is now coping with the caseload, given the fact that 2 new divisions have been organized. Because hindi siguro alam ni Presidente, I think it just, because he was extemporizing, he may have missed the fact that it's no longer in the Sandigan, but I'm sorry, in the Ombudsman, but in the Sandigan. But nevertheless, so can you give us a bird's eye view what the situation is after, 2 years or 1 year and a half, no? Since we organized. Yeah, we approved the bill 2 years ago. So last year it was all filled up. May we know, Justice Kabutahin Tam, what the situation is?
Good afternoon, Your Honors. We are glad to inform the honorable body that with the addition of the 2 new divisions, the Sandigan Bayan has quite significantly increased its disposition of cases, Your Honors. For the calendar year 2016, our performance target was 418 cases to be disposed, but we were only able to dispose 371 cases. But for this year, Your Honors, as of June 30, 2017, with a performance target of 418 cases disposed, we have so far disposed 442 cases, or a percentage accomplishment of 100.5.74%.
Can I have it again, Justice? Your June 30 target is?
For the whole year, Your
for the whole year is?
Yes, it's the performance target is 418.
418
cases disposed.
2017.
Yes, Your Honors. But as of June 30, 2017, we have disposed 442 cases.
442. So you have understated your target?
No, we surpassed our target, Your Honors.
Okay. That's one way of saying it. The other way is you have understated your targets. Because if your whole year is a disposition rate of 418 for 2017, and you're saying as of June 30, you have disposed of how many?
442, Your Honor.
442. Obviously, if you follow the same rate, you will get to 900 at the end of 2017. Right?
Well, maybe around 600.
That's a good indication, though. I mean, I'm not taking it against you, against the court. That means that what we did is working.
Yes, Your Honors, definitely.
Because precisely that was the reason for adding 2 more courts.
Yes, Your Honor.
2 more divisions, so that you have less load and you can calendar it faster. So that when I don't know why you were permitted to set it only at 418 as a target, when in fact you have already 7 divisions. But anyway, that's neither here nor there. But what I'm just pointing out is the objective of the law in adding 2 divisions, which is in order to hasten the resolution of the cases, is working as evidenced by the faster disposition rate. Is that correct?
Yes, Your Honor.
And that's all that. So,
may I just state for the record, Your Honors, that we arrived at the figure 418 by averaging the number of cases disposed for the immediate preceding 5 years. So we arrived at this 418 number. For the past 5 years, we added the number of disposed cases and divide it by 5, and we arrived at this figure.
That's not very accurate, because certainly if you have 1,000 cases before a division, it's so difficult to dispose it at a faster rate as against 500. So anyway, as I said, that's neither here nor there. What I'm glad is you're saying that maybe by the end of the year you'll hit 750 as a number of cases disposed. That's a reasonable expectation. And as against 418 or 371 as of 2016, that's more than, that's about double probably that you will dispose of.
We're hoping that it will be that way.
Double. Yeah, 371 times 2 is just 740 or something.
Yes, sure.
So that will double, and that is all that I'm trying to say,
Yes, sure.
that it was a correct solution. Of course, there was some resistance on procedural issues, I mean on issues involving the number of justices who can decide the case, but is that also being implemented now for new cases? You remember that what the law says?
Well, for cases that are filed now, Your Honors, well, we adopt the same procedure, except that we may need to apply already the quorum, the rule on quorum. Yes, Your Honors. Especially with the increasing number of cases that are filed with the court by the Office of the Ombudsman. Your Honors, I'm also glad to report that the number of years it takes the Sandigan Bayan to resolve cases has considerably been reduced. In the past, it was reported that it took the Sandigan Bayan around 9 years, 8 years to resolve cases, but as of this time, it takes only about 5.2 years to decide cases, and we're still trying our best, really, to dispose cases as fast as we can. But of course, there are certain constraints. I'd like to address, Your Honors, the issue regarding the delay in resolving cases involving senators. Well, there are...
I'm not going to say that.
Yes,
just
the issue that was posed.
Hindi po ako nagsabi nun.
Well, one of the cases is now undergoing trial, the case of Senator Revilla, which is being heard by the First Division of our court. Now, in our case, in the case of Senator Enrile, we cannot proceed with the trial, although it has been set for trial, because there are motions now pending, motions for inhibition. And of course, the resolution of these motions takes precedence, of course, before we can even act on or proceed to trial, Your Honors.
The simple answer to that statement of the President is, let us examine how many postponements were asked by the defense, and it will be shown that the reason many times for the non-hearing is the motions filed by the defense, by the accused. So,
just to say something, Your Honor. Now, by September 1 this year, we'll now be implementing our continuous trial in criminal cases. We will resolve the problem of motion for inhibition because we now require judges to resolve a motion for inhibition within 2 calendar days from submission. We have also required the scheduling of criminal cases from the arraignment. We prepare a flow chart. In other words, we set the trial dates within the periods required under the rules from the very beginning. So the party will ask for postponement. Whatever dates allotted to him, one postponement will be deducted from the dates allotted. So even if you grant postponement, if the prosecution is allowed to present its evidence for 8 trial days and he asks for postponement, then 1 trial date shall be deducted. So there will be no harm. The harm now will be on the part of the movement because he will be a date of trial shall be deducted, or a day of trial shall be deducted from the dates allotted. The other thing, you know, we're also try to solve the problem of sonographers. The work of the sonographers will now be easier in the courts because instead of a judicial affidavit as direct testimony, we require the sworn statements of complainants as the direct testimony. If the sworn statement of the complainants that are filed with the fiscal, then whatever affidavits that are filed before the fiscal shall now be the direct testimony. So the judicial affidavit will only be the third choice. So the direct testimony will already be abbreviated.
So the sworn statements submitted during the preliminary investigation?
It's either if the accused was arrested without a warrant and the police officers executed their affidavits of arrest, the affidavits of arrest will now become the direct testimony, subject to additional direct and cross-examination on the part of the
So you dispense with the judicial affidavit?
Yeah, that will be only the third choice. If the sworn statement is not available, and then it went through a preliminary investigation, then the affidavit complaints, counter affidavits, and affidavits of witnesses will all be the direct testimony. If the 2 are not available, then you avail of the judicial affidavit because fiscals are lazy to prepare a judicial affidavit. That's the problem with judicial
Did you experience that as a fiscal, that you were lazy? I know that you were diligent, so...
We were very fast, Your Honor. The fiscals are not different from the fiscals before. I think you know that. Yeah. The other one is that we now require, likewise, the courts to set the promulgation on the last day of the presentation of the evidence of the accused. And the date of the prolongation should be within the 90 days period allowed by the Constitution. So
There is no more memorandum?
we now discourage memorandum because that's not part of the rules. The only memorandum required are the rules on intellectual property cases and environmental law cases. There is no such rule on memorandum in regular cases, Your Honor.
Have you considered asking both parties to submit the decision if the judge would would rule in their favor?
During our time, there was a proposal to
Yes.
that effect when we were
Yes.
judges, but it did not work, Your Honor.
Why? Why will it
Well,
not?
the other party will always suspect.
No, both of them. Both of them.
You mean the draft decisions prepared?
Yes,
by the council?
instead of a memorandum, let them submit a draft decision. Both of them.
It was tested before, Your Honor, but it did not pass through the Supreme Court en banc. They tried it. They tried before. And there
I
is-
just want to know, what is the policy against it? Both, the accused or the plaintiff, in civil cases, the plaintiff and the defendant. Instead of filing a memorandum, they file a draft decision. In criminal cases, well, of course, mas mahirapan na akusado dahil wala siyang abogado. But where it is feasible,
Probably in the rule on summary procedure, but not in criminal cases, Your Honor.
Okay, in
because-
summary,
Yeah,
okay.
because one of the basis of convicting or acquitting accused would be the demeanor of the witness.
Yes.
And,
But maybe not in criminal cases, maybe in special proceedings or,
probably
in civil cases.
the rule on summary procedure
Yes.
allows it, Your Honor.
No.
The rule on summary procedure, yes, it depends upon the parties if they would like to.
No, why don't you include it in the rules?
We'll study that.
When study
in other
that, I
cases.
mean, there's nothing wrong with it. Instead of filing a memorandum,
Yeah.
file a draft decision.
Then the other one, Your Honor, is that the other reform that we undertook for purposes of resolving cases, or the rule on small claims. That rules on small claims has been very effective in reducing the docket of the first level courts. We are not anymore experiencing a high docket in the first level courts because of the rule on small claims. We do not anymore allow the appearance of lawyers. For obvious reasons, Your Honor.
Just one final point. If you recall, last year I had very close consultation, particularly with Justice Peralta and Justice Cabotahitang, on our effort to upgrade, I'm not calling to upgrade, but the penalties based on amounts of money. In other words, today or before the amendment, the amounts in the revised penal code where the penalty is based on the value of the property is circa 1932. We have updated that. It's now with the President, and it's supposed to, the 30 days is supposed to expire next week. So if I don't think he will veto it. There's no sense in vetoing it. It could lapse into law, and that should relieve
I read the draft, Your Honor, and because of our decision in the People versus Corpus, that's the one that precipitated Congress.
That's correct, yes.
Amen, yeah.
You the ponente.
Fortunately, unfortunately.
Yes. No,
That's correct,
we
that's
use that.
correct,
In my
Yeah, because there was an attempt to change the amounts through a decision, but I objected because that would be judicial legislation. So I think Congress heard about it, so they amended. But my only concern, Your Honor, is that the amount I think is too high. Let's take the case of theft. The present amount of theft, if the amount is more than 12,000 pesos, but does not exceed 22,000 pesos, then the penalty is prison correctional maximum up to prison mayor minimum. Now the proposal is that 12,000 to 22,000 pesos, I think you have raised that to 1.2 million pesos to 2.2 million pesos. So if somebody stole 1 million pesos, that means that is below 1.2 million pesos, that will be within the probation period. So a thief is stealing 1 million pesos.
You know, we were aware of that, Justice Peralta, except that we have to apply one standard to all the crimes. We cannot apply, we do not want to apply one standard to one case, one article, and another standard. Otherwise, there will be a never-ending debate on the floor and we'll never be able to pass it.
Anyway, I think you use the central bank
Yes.
index.
And NEDA.
NEDA index.
Yeah. So we just used one standard for every crime.
If that bill will become into law, then we expect around 40% or 40 to 50%, those who are not in jail will be released.
The estimate of the POW is about 52,000.
I think that's too
Too high?
Too high. Because those who will be only affected, Your Honor, will be those who were convicted of the crime of theft. Yeah, and those who are convicted of qualified theft. And those who are convicted of estafa, and probably those who are convicted of malversation. Yun ang talagang apat na affected because the penalty really is dependent on the amount, and there is an incremental penalty in excess of the amount fixed by the law. So other crimes probably like malicious mischief.
The reason for that indexation is precisely in our effort to index.
We will really
Yes.
and also
It's really equitable and fairer.
there is also a decision that will come that will decongest our jails. Then with due respect, we came out with a decision that plea bargaining should now be allowed in drug cases under Section 23 because there is a specific prohibition under Section 23 that plea bargaining is not allowed, but we consider that that is procedural and it is within the province of the court to promulgate such rule.
Yes. We appreciate that this is a system of check and balance.
So we expect a considerable reduction of criminal cases in the next year. Give us 1 year, Your Honor, and we will see the outcome. Those courts that were piloted for the continuous trial, there was an increase of, there was a significant improvement on the compliance with the trial periods from 14% to 75%. And rendition of judgment from a low as 50%, they went up to 92%, complying with the 90-day period to render a decision. So we expect and with the support of the Congress, Your Honor, there will be more improvements in the future.
Yeah, we respectfully suggest our chair to cite these efforts of the Supreme Court when the sponsorship speech is done to sponsor the measure, the budget of the judiciary. We have no more questions, Madam Chair. I don't think that we have any question of the CA. The CA has instituted a system which the Chief Justice or the presiding justice can monitor the age of every case. Is that correct, Justice Fernando?
Yes, Your Honor.
They can monitor the status of every case pending in the court.
At any given time. At any given time.
At any given time. So that you ask today, what is the status of Juan versus Pedro? Pending, they can tell you.
Is it online?
Yes.
Online. We have a website, Your Honor. www.ca.gov.ph.
How about the Court of Tax Appeals? Because when we were, I think it was a Ways and Means hearing, and the issue of VAT refunds was being discussed, and the BIR said that there was a backlog in terms of payment for VAT refund, which had financial repercussions on the allocation of budgets every year, because they said there was many pending cases in the CTA. I wonder if the CTA has adopted a similar measure as online updates like the Court of Appeals?
Thank you very much, Your Honors. Actually, the CTA is among the three collegial courts is the very first one that has adopted that particular system, wherein the status of cases could be actually checked online. But to be realistic about it, when a resolution is promulgated, let's say today, they can check it within 48 hours, within 2 days, Your Honor. So while we say that it is real time, in reality, it would take at least, or at most, 2 days, Your Honor, from the date of promulgation. Now, with respect to refund cases, the fact that a decision has been rendered by the Court of Tax Appeals is not already a guarantee by which the taxpayer could immediately get the refund. Problem is, from the Court of Tax Appeals, the case is elevated, or usually, if we go by statistics, no matter how unmeritorious the position of the bearer is, with due respect to the bearer, no matter how unmeritorious the case of the bearer is, the appeal always follows as a matter of course. And after the Supreme Court renders a judgment that has become final and executory, we really have information that the bearer is not able to make the refund immediately. So it is not so much a question of the judiciary being inefficient in rendering judgment, but it is because of the reaction of government, particularly the BIR, in giving out money for the taxpayer. The purpose of the BIR basically is to collect. That is why we find it very difficult, or the taxpayer finds it very difficult to actually get the refund despite a final and executory judgment by the court.
I asked the BIR for a list of all the tax refunds and how much do they need so that all the backlog can just be erased if you provide that in the 2018 budget. I've not received that. But the answer they gave us was it only takes them, is it 2 months, 1 or 2 months, to assess these VAT refunds, and it's elevated later on to the CTA, and they claimed, and as I misunderstood it, was the backlog is if it goes to court, hindi nila masabi kung ganong katagal yon. Is that accurate? No.
It is just unfortunate that the BIR is not here. But even if a case reaches the court already, the refund procedure continues. There is nothing that would prevent the BIR from proceeding with evaluating the refund. The point is, after the court renders judgment, that is going to be an entirely different thing, because the BIR has no authority to reverse a judgment of the court. But during the pendency of the case, the BIR has the full authority to proceed assessing and evaluating the claim for refund.
Ma'am?
Yes.
Is there a specific item in the General Appropriations Act which can be sourced for refunds pursuant to the decisions of the Court of Appeals, Court of Tax Appeals?
I'm not very familiar, Your Honor, with the budget or appropriation. But taxpayers, mostly taxpayers that file a claim for refund with the Court of Tax Appeals are big corporations. And they are so much satisfied if the amount being refunded is covered by a TCC credit certificate or a tax credit certificate.
Okay.
But even the tax credit certificate is very difficult to secure from the BIR. The resistance is indeed very strong in so far as the BIR is
tax
concerned.
credit.
Yes, Your Honors.
So that's the system.
They can use it for tax credit.
No,
Yes, Your Honor. The claim usually is tax refund or tax credit. But even if taxpayer seeking for a refund is more than satisfied with a tax credit, the difficulty still remains there. There is vigorous resistance on the part of the BIR to actually issue a tax credit certificate. As I said earlier, apparently the main purpose of the BIR is to collect rather than to refund.
Well, of course, I heard differently during the Ways and Means hearing, and they said, I think 120 days. They said from the time of the filing of the VAT refund, it only takes them 120 days to decide, and then it later all goes to the CTA, and then that's where the backlog, unless I misunderstood. But then I know that there is an allocation here of 8.5 billion. This is a 2000, in the NEP.
2017 and 2018.
Every year. So in answer to the question of Senator Drilon, it's used for tax credit and used for tax refund as well. They can apply it to both. And there's an annual allocation for tax refund. In 2018 NEP, it's 8.5 billion. I understand this is not even sufficient. That's why I was asking the BIR. I'll just remind the staff to get from them, magkano ba ang total tax refund? Because that's really unfair to the private sector. If our laws provide the VAT refund, for example, and if it's not refunded by the BIR, on paper lang silang meron refund, but they don't actually enjoy it.
That's true, Madam Chair, and this was a cause of irritation between Japan and the Philippines because of ODAs and the Japanese contractors were collected from the Japanese contractors. VAT was collected, and they're supposed to be refunded, but it takes time to refund. So nagagalit ang Hapon. So anyway, this was an issue in the executive branch. We have no more questions, Madam Chair, unless you still have questions.
Your Honor?
Ano?
Yes, thank you, Your Honor. But
Thank you ka na lang. Ano pa?
yes, but may I just put on record, Your Honor,
That
I would just like to continue with the additional budgetary request of the...
Pinapa-John ko na eh.
Again, then I submit, Your Honor.
Akala ko tapos na yung 570, Supreme Court and lower courts pa yun. Nakatingin ako kay Justice
In fairness to
nabasa ko yung...
in fairness to the CA and the Sandigan Bayan, if I may, Your Honor, respectfully request, if I may lang. But if not, then we are happy with the approval.
I think
we need to help the judiciary.
to be fair, we will listen to all the augmentations required. Sige na.
We'll just take 5 minutes, Your Honor.
Okay, go ahead. Yeah.
Thank you, Your Honor. For the Court of Appeals, they are asking for additional budgetary cover of 201 million, Your Honor. The major ticket items under MOE pertains to training and scholarship expenses.
Okay, then anyway, we have a hard copy. You can
Yes, Your Honor.
through it, yeah.
For the capital outlay, Your Honor, we just mentioned that they're asking for 92 million for the construction of a 5-story building in place of their existing building in the CA, and another 40 million for machinery and equipment. Finally, Your Honor, for the Sandigan Bayan, they're asking a total
Before you
of...
proceed, for the Court of Appeals, as of June 30, you actually have unobligated allotments of 1.1 billion. So while I understand, of course, that there's no deadline for you because you will not return it to Treasury by December, there's 1.1 as of June 30.
Yes, Your Honor, but may I just state that per the records of the CA right now, they have obligated much of these amounts already. They have a very high utilization rate, Your Honor.
Okay.
Yes, Your Honor. For the Sandigan Bayan, they're asking for a additional budgetary cover of 426 million, Your Honor. And the biggest...
And Justice Tang actually gave me an advance copy, and I have her letter. I went through it. I just have one question. It says security services. You mean if we don't grant you the 10.4 million for amendment, you don't have security?
They have...
Sandigan? Is that an additional security?
This will be an additional security services, Your Honors. We have organic members in our security staff, but we are veering towards hiring blue guards instead of having organic security guards, because sometimes we have problems, especially when let me cite an example of a security guard who was preventively suspended until he was ordered dismissed by the Supreme Court. So meantime, we cannot hire because his position cannot be considered vacant. So that means there is a...
You don't have to explain, I understand. I just went through the requests of the Sandigan Bayan and I saw security services. Sabi ko, kung di pagbigyan itong 10 million, wala kayong security, kayo pa kailangan nyo. Computer software. So actually, some of these amendments are really simple, very basic, but these are augmentation. And even if it's not granted, but I'm not saying it will not be granted, you can operate o mahihirapan kayo?
Mahihirapan po, Your Honors, especially dito sa hiring of security services.
There has to be a line item, Your Honor, because otherwise they won't be able to augment, Your Honor, that...
Tanungin ko nga.
Yes po.
Because all of this 1 up to 12
Yes, Your Honor.
of machinery, equipment, computer software, security, etc., you have, because you don't revert to Treasury,
Yes, Your
you
Honor.
have savings or continuing appropriations.
Yes, but they cannot use for this particular
Correct.
purposes,
If
Your Honor.
we make all of this and put line item for this,
Yes, Your
you
Honor.
will be able to fill it up
Yes, Your
from
Honor.
your savings or
If-
continuing appropriations.
Yes, Your Honor. When there are savings, Your Honor, yes.
Yes.
Yes,
correct.
Your Honor.
So you just need this names or
The items, Your
the
Honor.
items, correct.
They can only augment items in the budget. If there is no item, they cannot augment.
Attorney Villanueva is saying, Justice Tang, so in short, the Sandigan Bayan, for example, does not necessarily need exactly 426, but you need the expense class or the item, and then you can actually generate it from your continuing appropriations.
Your Honor, for the record, that is, the amount is actually what is needed, Your Honor. Of course, if some amounts will be given for those items, Your Honors, if there are savings, then that can be looked into, Your Honor, in case, just in case. Yes.
Your Honors, we are asking for the funding actually of this, not just the bahay po. Because although we have some savings, a big chunk of it has already been earmarked for some projects.
For June 30, as of June 30 this year, the Sandigan Bayan has 854 million.
But Your Honor, based on our records, Your Honors, the Sandigan Bayan also has a very high utilization rate, and many of those amounts, Your Honors, have already been obligated.
And
Your
the
Honor.
Court of Tax Appeals, 236 million. Just
Yes.
on the record.
Yes, Your
But
Honor.
I, of course, understand and realize that you need all of that. It's been
Yes, Your Honor. Yes, Your Honor. Your Honor.
happy to see all of you every year. And is there anything that any of our justices would like to say?
Yeah.
So the most important is the
We now move to approve.
yes, move to approve
At the
with
committee level,
possible amendments.
yes, and submit the budget to the plenary.
Thank you very much.
Thank you, Your Honor. Thank you very much.